The first thing I noticed was the fence. Not a backyard fence. This was permanent. Steel posts sunk deep. Stone pillars at the entrance. Wet landscaping from the morning hoses. And it was sitting exactly where my aunt's boundary markers were supposed to be. I parked on the gravel shoulder. Pulled out the survey copy from my glove compartment. Walked toward the crew finishing the gate. My boots hit the same cracked concrete marker I remembered from childhood visits. The numbers matched. This was the corner of the land my family had owned for decades. Except now, it was inside a gated neighborhood. I just stood there for a second, trying to make sense of it. This wasn't a misplaced fence or a temporary mistake. They hadn't just crossed the line, they had built over it. Then I saw how far it went. Rows of new homes stretched across the hill. A clubhouse. A playground. Even a small pond with a decorative fountain. All of it sitting on acreage my deed clearly showed as part of my inheritance. I pointed at the marker. This parcel belongs to me. A woman in a navy blazer stepped forward from near the gate. Calm. Polished. No, she said flatly. This land was absorbed during a boundary correction. You're mistaken. Behind her, workers kept installing fencing, sealing it in permanently. Security approached immediately, like they'd been trained to remove anyone not on the resident list. When she told them to escort me off, a small crowd of homeowners gathered, watching like I was trespassing. As I stepped back toward my truck, something caught my eye on the permit board near the gate. 2 plat maps. Same subdivision name. One yellowed and stamped years earlier, the boundary matching my survey. The other freshly posted, lines pushed outward into my parcel. My stomach dropped. This wasn't just a mistake. That's when I realized, someone had already redrawn my inheritance, and they were counting on me never noticing. I didn't sleep that night. I spread everything across my kitchen table, the deed, the tax records, the old survey. It didn't take long to see the pattern. No sale. No subdivision. No transfer. The parcel had stayed in my family the entire time, and the taxes had been paid every single year. Which meant that neighborhood hadn't just crossed a line. It had been built on land my family still legally owned. The next morning, I called the number listed on the subdivision sign. The same woman answered. Her voice was calm, rehearsed. I was out there yesterday, I said. Your development is sitting inside my boundary markers. A pause. Then, the subdivision boundaries are final. The county approved everything. That doesn't change my deed. You don't have access to that property, she replied. It's private community land. I own part of it. No, she said again, firmer this time. You don't. And I'd advise you not to return and disturb residents. The call ended before I could respond. 2 days later, a certified letter arrived. The return address was the HOA management office. Inside was a formal warning referencing my incident at the gate and accusing me of interfering with residents and disputing established property boundaries. It stated I was not permitted to enter the community and that further attempts could be treated as trespassing. I read it twice, then a third time. They weren't just dismissing me, they were documenting me. Building a record. If this escalated, it would look like I was harassing them over land they claimed was theirs. For a moment, I considered backing off. If they pushed this legally, I could end up fighting trespass claims while they kept building. That didn't sit right. I drove back anyway. The gate was closed this time. When I pulled up, the guard stepped out immediately. You're not authorized to enter, he said. I just need to check the boundary markers. Board instructions, he replied. You've been restricted from the property due to ownership disputes and resident complaints. I glanced past him. The stone marker was still there, now partially surrounded by newly planted shrubs. "I'm not trying to cause problems," I told him. "You need to leave," he said. This wasn't just an escort anymore. They had formally blocked access to land I believed I owned. I sat in my truck for a minute after pulling away. Hiring an attorney felt premature if this was just a paperwork error. If a boundary correction existed, it had to be recorded somewhere. I needed to see it first. So I went straight to the county records office. The database wasn't simple. Multiple filings. Amendments. Draft plats. Some labeled nearly the same. I started with the earliest subdivision submission, the one filed months before construction. Its boundary matched my family parcel. No overlap. Next, I opened the approval documents that followed. Planning review. Conditional approval. Still no change. Then, buried deeper in the chain, I found another entry. A revised plat submitted just days before final construction approval. The boundary lines were pushed outward, directly into my parcel. I checked the timestamps again. The revision was filed late. Approved shortly afterward. Construction authorization followed immediately. And I was only seeing it now, days after being turned away at the gate. That was the first time I realized this wasn't a misunderstanding. It was something that had been rushed through at the last possible moment, before anyone could question it. Once I found that boundary revision, everything started to feel wrong. The filing referenced a corrected subdivision plat, so I requested both versions, the original submission and the revised one. The clerk printed them side by side. The difference was immediate. The original map kept the development inside the developer's parcel. The revised version pushed the boundary outward, straight into the acreage I had inherited. Sections of the neighborhood now sat inside that new line. I pointed at the date stamps. The original plat had been logged weeks earlier. The revised one appeared only days before final approval. "Where's the supporting documentation?" I asked. The clerk searched the file. Then searched again. "There should be survey notes, easement releases, something explaining the correction," she said. There was nothing. No updated survey. No adjacent owner consent. No explanation for why the boundary moved at all. Just a replacement map. My stomach tightened. If that line was wrong, then homes had been built on land that never should have been approved. And if that was true, this wasn't a paperwork mistake, it was construction moving forward without clear ownership. 3 days later, another letter arrived. This one referenced continued reports from residents and included a formal harassment complaint. It warned that documenting property lines, contacting homeowners, or returning to the area could result in legal action and liability for interfering with community operations. They were escalating, and putting it in writing. I hadn't entered the neighborhood. I'd stayed on the roadside. But they were framing even that as disruptive. I went back the next morning anyway, keeping my truck on the public shoulder. If I was going to challenge this, I needed documentation. As long as I stayed outside the gate, I wasn't trespassing. I started photographing markers visible from the road. Some looked recently disturbed. One corner marker was partially buried under fresh sod. While I was crouched taking photos, a homeowner walked over from a nearby driveway. "Why are you taking pictures?" he asked. "I'm documenting boundary markers." He crossed his arms. "The HOA told us someone might come around making claims. This is private property." "Not all of it," I said. He shook his head. "We bought these homes. Everything was verified." I stayed on the roadside and kept photographing. But the tone had shifted. He didn't leave right away, just stood there watching. The next day, another resident slowed while driving past, staring at my truck before continuing. Later that afternoon, I noticed 2 people standing near the entrance talking while glancing in my direction. No confrontation, just awareness. Over the next few days, the attention grew more obvious. People noticed when I drove by. One afternoon, a resident followed my truck for 2 blocks before turning off. Another day, someone stepped outside with a phone while I photographed a marker. It felt less like curiosity and more like they were keeping track. Then the signage appeared. A new sign near the entrance read, "No trespassing, community under video surveillance." Cameras that hadn't been there before now pointed toward the road. It felt coordinated. Like the awareness had turned into a plan. The more it happened, the harder it got to ignore the risk. They were documenting everything. If they pushed this far enough, I could be dragged into a legal fight before I even proved the boundary was wrong. And that's when doubt started creeping in. What if I was missing something? What if the correction was legitimate and I just hadn't found the paperwork yet? Maybe there was an easement my aunt never mentioned. Maybe the developer had negotiated something years ago. I kept staring at the roadside marker, trying to convince myself the numbers still meant something. "You're looking at that line like it doesn't make sense," a voice said behind me. I turned. An older man stood there wearing a faded cap, a folded tripod over his shoulder. "It doesn't," I said. He stepped closer, studying the marker, then the fence line. He didn't say anything at first. Just crouched down, brushed away dirt, and checked the orientation. After a long moment, he stood and looked again, slower this time. "You mind if I take a quick sight?" he asked. "Go ahead." He extended the tripod, glanced along the line, then lowered it again. "Hard to say without pulling records," he said carefully. "But that fence, it looks like it might sit past where the original boundary should run." My chest tightened. "So I'm not imagining it?" He hesitated. "I'd want to compare it to the recorded plat before saying for sure. But something about that angle doesn't line up." "You're a surveyor?" "Retired," he said. 40 years. He looked back at the neighborhood. "If that line's off, it's not a small mistake. That's a deliberate shift." Relief hit first, then something colder. Because if he was even partly right, this wasn't just my claim anymore. Someone else could see the discrepancy. Which meant whatever happened next, wasn't going to stay quiet. The retired surveyor returned a few days later, bringing a full setup, tripod, measuring tools, and charts. He asked to work from the public right-of-way, and I stayed beside him while he lined up site points with the original marker. He didn't rush. Adjusted, checked angles, made notes. After a short pause, he looked toward the gated entrance. "Looks like they expanded," he said carefully. "Not tiny either. That fence runs past the recorded boundary." "How far?" I asked. "Enough to include several lots. I'd want to double-check with records, but it's significant." I felt my chest tighten. Multiple homes, maybe families, were potentially sitting outside the legally approved boundary. The realization hit harder than I expected. This wasn't just a fence. It was entire properties built on disputed land. I thanked him, took photos of his reference points, and called a property attorney before leaving the site. The attorney reviewed the documents the next day. He didn't just confirm the boundary discrepancy, he highlighted the risk. "Approvals appear to have been signed without adjacent owner consent," he said. "That exposes both the developer and anyone who allowed it. You could face claims if this escalates before it's corrected." I realized the stakes weren't only about land. They were about liability, reputation, and legal exposure. A few days later, the HOA responded. This time it wasn't just letters, it was a formal notice accusing me of trespass and interference. It warned that continued activity near the disputed area could result in legal action and financial damages. Soon after, temporary security stakes with printed signs appeared along the fence line where the surveyor believed the boundary had shifted. A few were planted near the edges of specific lots that bordered my parcel. They marked the strip of land between the original marker and the new fence as area under ownership review. The placement made it obvious. The signs followed the same stretch where the boundary appeared to have moved, not the entire neighborhood, just the disputed section. I received an anonymous forwarded email from a resident. A community meeting was scheduled, titled Ownership Dispute Clarification. I wasn't invited. Aware that showing up might escalate matters, I listened from the public sidewalk outside the clubhouse, staying visible but non-confrontational. Inside, residents murmured anxiously. One whispered to another, "Do you think our property's at risk?" The board president finally spoke. Calm, polished, but firm. An individual claims ownership of portions of our community. We are addressing it through proper channels. Residents should avoid engagement and report any contact. Another resident asked, "Then why is he taking pictures?" "He's attempting to create confusion," the president replied. Hearing that, knowing she'd seen the mismatched maps, made my stomach drop. She wasn't uncertain. She was actively dismissing the possibility and framing me as a threat. When the meeting ended, people walked past me with cautious glances. I felt isolated, like the antagonist in a story I hadn't written. Sympathy for the residents tangled with my own urgency to protect what was mine. Back at the attorney's office, he spread the revised plat over the original parcel. Several homes, plus some common areas, may be outside approved limits. And the approvals for this revision were signed without documentation. He tapped the page. If this is correct, someone knowingly allowed the expansion. I stared at the map. Shock hit first, then a chill. This wasn't a mistake anymore. It was a deliberate decision. And now, the legal exposure, for the developer, the HOA, and potentially for me, made every step forward more dangerous. A week later, the tone shifted. Instead of another warning, my attorney received an email requesting a settlement discussion. The HOA wanted to resolve the matter privately. No more letters. No more threats. Just a proposal to avoid unnecessary disruption. It felt almost too easy. We met in a neutral conference room. The board president sat across from me, calm as ever, with the HOA's attorney beside her. They slid a document across the table. The offer was simple on paper: they would purchase the disputed portion of my parcel. A lump sum payment, covering the acreage and what they called additional inconvenience. In return, would transfer ownership and sign a non-disclosure agreement. No litigation, their attorney said. No uncertainty for homeowners. I noticed the subtle hesitation in my own attorney's eyes. Not a refusal, just a quiet pause. Something felt off. The amount wasn't life-changing, but it was enough to make part of me consider ending it all. No more letters, no more residents staring at me like a threat. Just closure. You'd walk away clean, the board president added. Everyone moves forward. I studied the paper. Fine print. Multiple sections. Payment schedules. Transfer language, all seemingly in order. Minor points were adjusted. Everything appeared settled. For a moment, I let myself believe it might end. Later that evening, I went over the document carefully, section by section. Dense language. Legal jargon. I skimmed, then scanned again. And then I saw it. Buried near the end, a clause stating I waived all rights to challenge not just the disputed portion, but the entire subdivision boundary. My heart sank. Selling the disputed strip would mean I gave up only the land inside the fence. But this clause went further. It required me to acknowledge the revised plat as correct everywhere, including lots beyond the portion they were buying. If I signed, I wouldn't just sell land. I'd be confirming their expanded boundary as legitimate, permanently. Every home built beyond the original line would be protected, and I'd lose the right to question any of it later. Relief turned to suspicion. Relief at the apparent resolution. Suspicion at the hidden scope. And finally, a cold realization: this wasn't a settlement. It was a quiet way to rewrite ownership permanently. The moral weight hit next. Accepting would ease the dispute and spare homeowners stress, but it would also mean giving up principle and cementing a possible wrongdoing. Rejecting it meant prolonged conflict, legal battles, and personal risk. I leaned back in my chair. The room felt heavier now. Every choice carried consequences far beyond the table in front of me. I told my attorney the next morning. I wasn't signing it. He nodded. Then the settlement collapses. It did, fast. Over the next several days, the HOA escalated formally. A liability warning arrived claiming my refusal was causing financial harm. Pending home sales were stalling, buyers hesitating, and they warned that continued delays could lead to damages, and potentially hold me responsible. The message was clear: the neighborhood was now counting me as the problem. Social pressure built gradually. One afternoon, a homeowner stepped into the road as I slowed near the entrance. His voice was tired. "Are you the one holding this up?" "I'm trying to clarify ownership," I said. "We're supposed to close next week," he replied. Buyers heard about the dispute. Now they're hesitant. Another neighbor joined, asking, "Why not just take the deal?" I tried explaining the boundary wasn't mine to move, but it didn't land. Rumors had spread, HOA updates, conversations between residents, and quiet speculation had already framed me as the obstacle. I felt isolated and guilty, yet trapped. Every drive past the neighborhood risked confrontation, but I needed to observe and document what was happening. Over the next few days, the tension spilled beyond the street. I overheard residents talking near the entrance, repeating partial details. Someone pointed at my truck while speaking on a phone. The story was spreading, piece by piece, without me ever being part of it. Then the online backlash began. Community posts appeared in local forums, screenshots of my truck, accusations that I was trying to take homes, claims that families were at risk. Comments piled on, each one pushing the narrative further. My reputation was being rewritten publicly, step by step. Amid that pressure, my attorney kept digging. He requested the developer's correspondence tied to the boundary revision. A short chain of emails arrived: minor adjustment discussed, with a note showing the developer pushed for the revision before final approval. Suspicious, but not definitive, just enough to raise questions. A few days later, a call came from a title insurance representative. They requested a private meeting. When we met, the representative slid a folder across the table. "We've reviewed the dispute. If the original boundary stands, several insured properties may fall into uncertain ownership." My chest tightened. "Concerns?" "They were flagged before final approvals," the representative said cautiously. "But the project moved forward." My attorney asked, "Who was warned?" The representative hesitated. "Developer raised the risk, and HOA leadership was notified." I leaned back, processing it. Someone had been warned, yet the expansion proceeded anyway. The risk wasn't abstract anymore, it was deliberate. And now legal exposure, reputational damage, and community pressure were all converging. The hearing was scheduled 3 weeks later. After the title company meeting, my attorney moved quickly. He filed a petition challenging the revised boundary and requested a court review of the approvals. The HOA responded, disputing my claim and defending the revision. The judge set a hearing to evaluate the documents and determine whether the boundary change could stand. By then, property transfers inside the neighborhood had slowed to a trickle. Rumors were everywhere. Some residents avoided eye contact as I drove past. Others watched openly, as if the outcome would decide their future. Honestly, it probably would. Inside the hearing room, the air felt heavier than I expected. No raised voices. Just stacks of binders, printed maps, and the same two plat versions that had started all of this. My chest tightened. Every eye on the documents carried a question: would this line on a map hold? My attorney went first. He laid out the timeline: original boundary, last-minute revision, missing documentation. Then he introduced the title company records, emphasizing the warnings raised before final approval. The room shifted subtly. I felt the uncertainty pressing down. Could the HOA counter this? Next, he called the board president forward. Calm as ever, she walked up, posture unflinching. My attorney handed her the revised plat. "You approve this boundary?" "Yes," she said. Pause. Our understanding was the developer had addressed any concerns. He slid over the internal communication summary from the title company. "This note indicates you were informed the adjustment might extend into adjacent land without confirmed consent." Her eyes flickered to the page. "I don't recall that specific language. But you signed approval after receiving this communication?" "Yes, based on the information provided." The silence that followed wasn't theatrical, it was weighty. I could feel the tension in every person seated there. The reality of what had been signed, despite warnings, was settling. Then came the developer correspondence. My attorney highlighted the minor adjustment request, showing the date, after preliminary approval, before final sign-off. So the boundary expanded despite warnings and without adjacent owner agreement, he concluded. The HOA attorney argued the change was administrative. Homeowners had purchased in good faith. Undoing boundaries would create unnecessary harm. I swallowed hard. He wasn't wrong about the residents. But this hearing wasn't about sympathy, it was about the approval itself. Finally, both plats were placed side by side. The difference was impossible to ignore. Entire portions of the subdivision shifted outward. If the original boundary controls, my attorney said, multiple structures fall outside approved limits. This stems directly from the revised approval signed despite prior risk warnings. The judge leaned back, eyes narrowed. The room went quiet. We waited while the decision was reviewed. Minutes stretched. My stomach knotted. Every outcome carried consequences, not just for me, but for families already living on the disputed land. After a short recess, the court issued an interim order: property transfers affecting the disputed area were temporarily halted. No sales. No boundary changes. Everything frozen until final determination. Construction, occupancy, and transfers were all paused. Outside, residents waited in small groups, clearly aware the hearing was taking place. Anxiety showed in their posture, whispers buzzing in the air. Some glanced at me, unsure. Others simply stared, realizing for the first time that this line on a map could change everything. I didn't feel victorious. The interim order was only a step, a temporary halt. But it was the first time the power had shifted. The HOA could no longer dismiss the claim outright. Their leadership, the same people who told me I was mistaken, now faced documented questions about how the boundary had moved. And for the first time, I understood how high the stakes really were. This wasn't a technicality. It was about the ground beneath the houses, the futures of families, and whether the truth of ownership would finally matter. Months later, the court finally issued its ruling. Portions of the subdivision had indeed been built beyond the legal boundary. The developer and HOA leadership were held responsible for the unauthorized expansion. Residents were allowed to remain, but the fix was complicated. Some lots were adjusted inward where possible. Others received permanent easements across my land, with compensation paid to me for the encroached sections. New surveys were recorded, fences shifted, and boundaries redrawn to match what the court approved. It wasn't perfect, but it was accountability. The HOA board president resigned quietly, a direct consequence of the ruling. Governance was overhauled, stricter approval reviews, mandatory confirmation of adjacent ownership, and transparent documentation now required. I didn't celebrate with fanfare. This wasn't about proving a personal victory, it was about ensuring no one else's inheritance would be quietly erased in the future. Returning to my property was surreal. Standing on that land, I felt both heavier and lighter. Heavier because the fight had exposed how easily decades of family history could be jeopardized. Lighter because the maps finally matched reality, the line on paper reflected the ground beneath my feet. Homeowners adjusted. Some seemed relieved their homes weren't at risk. Others eyed the corrected boundaries and newly recorded easements warily, aware the dispute had permanently changed their lots. The community had endured financial and reputational damage, and the story lingered as a cautionary example of unchecked authority. Driving past the pond and the freshly surveyed lines, I realized the fight wasn't just about boundaries, it was about fairness, accountability, and knowing when to stand firm. Even now, I can't stop wondering. How many other properties quietly changed hands under similar circumstances? How many families lost ground they never knew they had? For me, the lesson is clear. Vigilance, records, and persistence are the only protection against losing what's rightfully yours. So if you ever face someone quietly rewriting the rules, stand firm. Gather proof. Don't let intimidation silence you. What would you have done in my place? Walked away, or fought to reclaim what was yours?